want to warmly welcome Professor Solomon Kundayo Salako. Over to you to please introduce yourself as well as you possibly want to, and address your thoughts as appropriate. I think you need to unmute yourself. You need to unmute yourself, Professor. Thank you. Over to you.
Yes. I'm Professor Solomon Salako. I'm a professor of law at Liverpool Hope University. My research interests are in international law, international relations, constitutional law, human rights, and jurisprudence, among others. I've listened attentively to all the submissions. There are certain inaccuracies there as relates to international law, especially the submissions of the Baashegun Alabe and the last speaker on supremacy. One was on the right to self-determination vis-a-vis the Nigerian Constitution, and the last speaker on the supremacy of the American Constitution. Every state, even United States of America, is subject to international law. I've been going forwards and backwards because I've been looking for materials, and I'm prepared to share some of these materials. I'll give my email address to whoever wants to contact me after that. But the first submission I find extremely stimulating because of the historical excursus by Barrister Dele Ogun. He took us through the history, the constitutional history of Nigeria, choosing as a starting point 1st January 1900. Then he went to 1914, 1954, 1966, the program, 1967, Abuja Accord, 1967 to 1970, the Civil War, Biafran War, the 1979 Constitution, which I'm going to refer occasionally to, and the 1999 Constitution, which I have by my side as well. But these are the three important points that we can pick from what he has said. He posed the rhetorical question, is unity negotiable? And he answered succinctly by stating, no self-respecting African will say it is not negotiable. It is either done by war or peacefully, which I commend. The second one is the Constitution itself. And I've had quite a lot of written and unwritten Constitution. I think what we use in constitutional law nowadays is enacted and unenacted Constitution. Nigerian Constitution is enacted. American Constitution, US Constitution is enacted. The British Constitution is unenacted because there are two universally acceptable definitions of Constitution, the abstract and the concrete. If you use the abstract Constitution, you will see that every state has a Constitution. If you use the concrete definition, that's where you fall into the trap of calling something written when it's either enacted, you want to say, or enacted. But he made an important point. He said the Constitution is a negotiated document. That is a vital point there. The Constitution itself, when we are talking about negotiability or non-negotiability, is a negotiated document. A consensus, according to him, which is couched in legal terms. It is a consensus. But do we have that consensus? I have here the 1979 Constitution, the suspension of that Constitution. Another one made by the military, the Constitution of the Federal Republic of Nigeria, 1989. And last but not the least, the 1999 Constitution. That's why I've been going forwards and backwards to pick all the materials, because I got a very short notice from the Erelu last night. She knows that, well, I'm always available. Then, Barrister Ogun mentioned legitimacy, the knowledge of the authors of the document. Who are these authors of the document? Who are these representatives? are they representatives of the peoples of Nigeria? And I agreed with him when he called the 1999 Constitution a fraud, which it is. Quickly, let us go to the Deputy Governor, Senator Sefiu Adegbenga Kaka. Well, he concurred with the plank on which Barrister Dele Ogun's argument rests, that the unity of Nigeria is negotiable, and also agreed that the authors are unknown. But he made two vital points by referring to the 68 items made in the exclusive list. But he then mentioned principles of federalism were not adhered to. But he did not specify what these principles are for those who are listening. There are three principles of federalism. One, separateness and independence of each government. Two, mutual non-interference or intergovernmental immunity. And three, reasonable balance between units of federation. In fact, these principles are honored in their breach than in their enforcement since independence. So it's not typical to when we started having military regime. But the vital conclusion he made, which I want everybody attending to take home, is that a unity government controlled by the military is masquerading as a federal state. What we've been having is unity governments masquerading as federal state. They are not federal states or federalism stricto sensu. Now, Mr. Ayobami Ogedengbe, the vital contribution he made is to introduce the issue of cultures and autochthony. And that is an addendum to what Barrister Ogun said. What is autochthony? That it is homegrown and it is homebred. It is indigenous to the people. We have 371 ethnic groups, as Barrister Dele Ogun rightly stated. He referred to the need for autochthony, even though he did not use that term. Why is that important? Quite a lot of people, including Mr. Okenla, have been saying that, well, even when we get the Oodua state, it's going to be the same thing. But we will write a constitution which is autochthonous. Everyone will participate in the constitution. It will not be signed in by a military government. That is the contribution to the debate. Now, let me now go straight to Mr. Olasupo Ojo. Mr. Ojo mentioned Section 2 of the 1999 Constitution. Nigeria is one indivisible and indissoluble sovereign state to be known by the name of the Federal Republic of Nigeria. Now, that sovereignty is indivisible is Austinian, John Austin, 1790 to 1859. Quite a lot of jurists in this country, HLA, did not accept that sovereignty is indivisible, or that the supremacy of our American Constitution is so intact that they cannot be bound by international treaties. I'm going to come to that later on. But he then went and then mentioned the cultural aspect, which is very good. Whenever we consider law, we always consider the substantive, the procedural aspects, the structural aspects, but we leave the cultural aspects. You see, every society reveals through its laws the way it manages people. And that is why the cultural aspect is very important. Again, he referred to legitimacy and that it is fraudulent. But he advocated the right to self-determination without expanding on that. The person who expanded on self-determination is Chief Dr. Shola Oni. But there are certain errata that I wanted to add. Not errata that I wanted to add to that. Self-determination as an inalienable right since 1983. That is not entirely correct. Self-determination started in 1966, International Covenant on Civil and Political Rights. And why this is so is that, well, if you look at a case decided by the Permanent Court of International Justice, that is the predecessor of the International Court of Justice. If you look at the opinion of Judge Ancelotti in the Permanent Court of Justice advisory opinion on the customs regime between Germany and Austria, reports of the PCIJ Series AB, number 41, 5th of September 1931, at pages 57 to 58, where he said, and I quote, "Independence, as thus understood, is really no more than the normal condition of states, according to the international law. It may also be described as sovereignty or external sovereignty, by which is meant that the state has over it no authority than that of international law. It follows that the legal conception of independence has nothing to do with a state's submission to international law. Irrespective of what is in the Constitution, and I'm going to come to the American Constitution, the state is bound by international law, by all those treaties, whether ratified or not in some cases. They are bound by those, whether they've incorporated them into their constitution or not. And that is what those judges were referring to in the cases Dr. Oni cited. I had to go up and then search my archives to pull that out quickly when he was delivering that. Now, before I come to summarize everything, let me quickly refer to the last three submissions. Very interesting. The first one is Mr. Kayode Okenla. He described Nigeria as a fractured state with a defective constitution. Again, he mentioned unlegitimacy. As a scholar, what baffles me is that, well, when he faced the question, what is to be done? In fact, he was not forthcoming on what is to be done. Do we stand idly by? Action is better than inaction. He said, I don't have the solution, but there are solutions. I said, see Barrister Dele Ogun and Dr. Shola Oni. In fact, if you have my email address, I will send a lengthy paper I presented on the 7th of June, 2014, in a lecture organized by Erelu in London to the descendants of Odudua and the Council of Elders, America and Europe. I'll send it to you. My email address is S for Solomon, E for Ekundayo, Salako, 93@gmail.com. I repeat that. S for Solomon, E for Ekundayo, Salako in lowercase, 93@gmail.com. Quickly, now two more. Attorney Ayodele Ojo, he mentioned a conflict of cultures and civilizations, which is an extrapolation of what we've been discussing, autochthony, etc., and then the defects in the constitution. But he believes, and this is very important, that a peaceful exercise of the right to self-determination is feasible, not visible, feasible. Now, the last one, Attorney Tinu Akishola said was in support of the creation of the Odua state. I'm in support too. But he compared the US Constitution and the Nigerian Constitution. They are both classical, they're both supposed to be federalist constitutions. But US is a secular state. And Nigeria also was a secular state until 1999. Section 10 of the 1979 Constitution states, and I read, the government of the federation or of a state shall not adopt any religion as state religion. So, which means Nigeria was a secular state until 1999. It was in 1999 that this changed. Again, he believed, as most of us believe, that she believed that, as most of us believe, that Nigerian unity is negotiable. That brings me to the conclusion. What do we draw from all this? It has been a long day. What do we draw from this? One is that the preamble to the Constitution, we the people, etc., is a fallacy, because it was not autochthonous, it was not a constitution of the people. Who are these people who drafted the Constitution? Who are they? Did they sign the Constitution as the founding fathers in America did? Did they do that? It was signed in by the military. Then legitimacy, that comes from that. Who are the authors, which I have said, of the 1999 Constitution? And I agree with Barrister Dele Ogun. It is a fraud because of that. Two, the Constitution is not autochthonous. In other words, it is not homegrown, homebred, indigenous from the soil. That is what autochthony, derived from the Greek word autochthon. Again, unity or loyalty cannot be commanded. I agreed with the speaker who made that statement. Unity or loyalty cannot be commanded. It's either it subsists or it does not. 4, is unity of Nigeria negotiable? The answer was succinctly put by Barrister Dele Ogun. No self-respecting African, he didn't say Nigeria, and I like that. No self-respecting African will say that it is not negotiable. What is to be done? Doing nothing is not an option. The question is whether it is done by war or peacefully. I'm a liberal scholar. I was trained in liberal institutions. I don't believe in wars. They don't achieve anything. That brings us to the right to self-determination, which is part of customary international law. No state can refuse this. Now, why am I saying this? That brings me to the issue of supremacy of American Constitution. I wrote a paper, a rather long paper, published in 2019, The Individual and International Law, Object versus Subject. At one portion, I said, the ICC is a treaty-based court with powers not only to prosecute, yes, that I went on by stating that Article 12 of the ICC statute reduces the need to ratification of the treaty by national governments by providing ICC with jurisdiction over non-party states, which include the United States. The United States purportedly circumvented Article 12 by refusing to join or support the court, by pressing other countries to sign treaties exempting US citizens from the court proceedings, and by cutting US foreign assistance to selected countries unless they sign immunity agreement with Washington. There is one pertinent question. Are the treaties signed by the United States and less powerful states exempting US citizens from court proceedings legal? US officials relying on Article 98(1) of the ICC statute, which stipulates that the ICC may not proceed with a request for the surrender or assistance, which will require the requested state to act inconsistently with its obligation under international law relating to the state or diplomatic immunity of person or property of a third party, asserts that the immunity treaties are valid. Lawyers for EU and many other governments have concluded that the US-sponsored immunity treaties violate Article 98 of the ICC statute and are in breach of the obligations under international law, because the article was designed to enable a state that had already existing status of forces agreement with other countries avoid violating these agreements with other forces they are hosting. Accordingly, EU members have refused to sign immunity treaties with the United States on legal and political grounds that do so would breach the Rome Statute and undermine ICC prospect. If Attorney Akinshola emails me, I will send an electronic copy of this paper to her straight away. To conclude,
thank you very much indeed.
One sentence. Examples abound where the right to self-determination has been exercised. In Bangladesh in 1971, Czechoslovakia in 1993, South Sudan 2011, former USSR and former Yugoslavia. A peaceful exercise of the right to self-determination, as Dr. Shola Oni rightfully stated, under international law is not only desirable, but also feasible. And Odudua Republic is feasible under international law. That seems to be a conclusion of.
Thank you very much indeed.